Y miembro de la Asociación Argentina de Juicios por Jurados.
Buenas tardes a todos, muchas gracias por permanecer con nosotros acá. Es la última conferencia, un solo panelista y viene desde muy lejos y tiene para contarnos todo otro mundo que es el de el juicio por jurados en el mundo asiático. El doctor Hiroshi Fukurai es PhD y profesor de Sociología y Estudios Jurídicos de la Universidad de California. Tiene experiencia en temas de participación ciudadana en sistemas de justicia, principalmente juicio por jurados, derecho internacional, política, raza y desigualdad, movimientos sociales, justicia ambiental, conocimiento indígena y sobre todo ha trabajado en métodos cuantitativos avanzados. El doctor integra la Sociedad de Ley y Leyes, es integrante también y socio fundador de la Asociación Asiática de Ley y Sociedad, y en este momento está aquí en su carácter también de presidente. Cumple con este cargo desde el año 2018, cuando fue seleccionado por los socios de la sociedad, hasta el año 2020. Forma parte también de la junta editorial de la Asociación Asiática de Ley y Sociedad y es parte del consejo editorial de la revista de Asian Journal of Law and Society de Cambridge University Press. Tiene más de 100 publicaciones, muchísimos libros y investigaciones en varios países de Asia, además de en Japón, de donde él es oriundo. Así que un gusto tenerlo por aquí.
Thank you, Sidonie, for a very generous introduction. I appreciate that. I'm sure you must be tired. But I will speak about 30 minutes. And then I was told that the 15 minutes will be reserved for Q&A. And I actually prepared for a 45 minutes talk, so I will talk it up fast, so I may skip some of the slides, so I can finish in 30 minutes, so that we have ample time for questions. Okay? First of all, muchas gracias por su invitación por este muy importante Congreso Internacional de Juicio por Jurado. Mi capacidad de hablar español es muy limitada. So, mi presentación es en inglés. Mi apología profundamente para mi incapacidad de presentar en español. So, title of my presentation is Lay Participation in Japan. And the subtitle is the Mixed Tribunal in Criminal Trial, Prosecution Review Commission, which is also known as the Grand Jury, and civil jury trial in Japan. And before I start talking about the system of lay participation in Japan, it is important to realize that many systems of lay participation have been introduced in many Asian countries besides Japan. People's Republic of China, for example, adopted new constitution in late 1940s. And just like the constitution in Argentina, it had a provision for a lay participation system. But because of the leader Mao's distaste of the lay participation system, so it was not being realized for many decades. So it's only last 20 years the Chinese government has enacted a series of laws to realize their own system of lay participation, which they call system of lay assessors. And they have adopted it not only in the criminal case, but also civil case. And it's a combination of one professional judge and two citizen judges. That's a PRC, that's a Chino, the People's Republic of China. The Korea has introduced its own system of American-style jury system in 2008. Instead of using the 12 citizens to adjudicate criminal cases, they adopted the 3 collegial models of lay participation, consisting of 5 citizen panel, 7 citizen panel, and lastly 9 citizen panel. And the size of panel depends on the severity of criminal charges being assessed against the defendant. So that's Korea. And Taiwan has been deliberating on the various systems of lay participation for the past 10 years. And Judicial UN, which is the highest judicial organ in Taiwan, had announced about 10 years ago to adapt the mixed tribunal system. That is not American style, all citizen jury system, but it's a mixture of lay judge as well as the professional judges. But this discussion has changed when the new president came into the office 2 years ago, and it's she declared, as soon as she got into the office, decided to declare to introduce the American style, all citizen jury system. But nonetheless, Judicial UN recently moved to actually declare to introduce Japanese style mixed tribunal system and called Saiban in Taiwanese soil. So those are the kind of new movements happening. And tomorrow, Nikolai from Canada, originally from Russia, will talk about the new systems being adopted in many of the former Soviet republics, like Kazakhstan, Georgia. Those are like in countries in the Central Asia, as well as northern western region of Asia. So I think his presentation is going to also give you a very different system of lay participation adopted in other countries. The reason I selected Japan is that Japan, for the last 100 years, had applied and adapted different forms of lay participation. For example, Japan has adopted American-style all-citizen 12-member jury trial from 1928 to 1943 for 15 years. It was only suspended because of the Second World War. Japan also adopted American-style 12-member civil jury trial from 1960s until 1972 in the island of Okinawa. That's a prefecture of Okinawa. Prefecture is like provinces in Argentina or states in the United States. It's the geopolitical unit. Okay? There are 47 prefectures in Japan. So the civil jury trial was adopted in prefecture or state of Okinawa. And of course, the mixed tribunal system was most recently adopted 2009, which I will talk about first. Japan also adopted very unique grand jury system. It's called the Prosecution Review Commission. Usually prosecutors are the only body in the legal system with the power to issue the indictment, right? Indictment. Okay. In the case of Japan, not only the prosecutors, but also the citizen panel composed of randomly selected 11 citizens. That panel was empowered to make indictment decision. And it was introduced in 1948. And the new revision strengthened the power of that citizen panel to indict, especially the people who are kind of historically being evaded from being indicted by the public prosecutors, like the people in the public offices, including politicians, or people who are very powerful in the corporate world, right? And also in the government bureaucrats. So those are the people prosecutors were reluctant historically to indict. So citizens panel began to look at the decision made by the prosecutors and evaluate, and now have the legally binding power to initiate the formal mandatory prosecution or formally kind of group of individuals that prosecutors were reluctant to prosecute. So those are the stuff I'm going to talk about. Okay, let's go to the first panel and slide. Thank you. Okay, now I'm going to talk about the most recent, the lay participation system adopted in Japan. It's called the Saiban trial. And it is called mixed tribunal, or which I call quasi-jury. It's not quite the same as the all-citizen American-style jury system. It's a quasi, it's similar to that. But it's composed of the panel of 3 professional judges and 6 citizen judges. So it's a combination of professional and lay judges. The kind of system that Cordoba had adopted, 2005, 2006. Even though Cordoba had transformed their system into the all-citizen jury system, which I envision that Japan hopefully will do the same path and follow the path. Also, they adjudicate the serious felony cases. And it is based on the special majority rule. So there's 9 people, right? 3 professional judges, 6 lay judges. So 5 decision becomes a final decision. But nonetheless, the majority vote must have a vote from at least 1 judge. And otherwise, it doesn't constitute legal. That's why it's called the special majority rule. And they will make a decision, guilt, and upon guilt, then they make a decision, the severity of sentence. And so everyone is eligible as long as you are 20 years of age. And your names in the voter rolls, okay, were used to select the potential candidates for the lay judges. And since it was adopted in 2009, this year is the 10th anniversary. And actually the裁判員Act, this law, was passed in May. So this is exactly the 10th anniversary of this system. And if you look at the picture, and you see 9 people sitting in the back, right? And in the middle, people with 1 designated on the head. Those are the professional judges sitting in the center of the bench. And then you have half of the people, lay judges on the left and right side. Then you have 4 designated for public prosecutors, and 5 is the defense attorney. And so that's how the Japanese court look like if you go to Japanese court. And let's see. So I have a most recent statistics. And numbers are based upon the report from 2009 from the quasi-jury was being adopted until 2018. And but I have a most recent statistics that is by the end of February of this year. And almost 12,000 defendants were being tried by this quasi-jury system. It's a lot of number of people. And also the little less than 70,000 jurors served in those trials. And you will see 22,000 alternates because each裁判員trial, usually you have 2 alternates. In case that there are 2 people get sick, right? Then those people can be replaced by the people who are chosen as alternate. And so that you don't have to start from the scratch, the trial. So together, you have more than 90,000 Japanese people served as jurors over the period of 10 years. It's a lot of number. But the length of the trial has extended. When it was adopted in 2009, 3.7 days. That's the average length of trial. So if trial started from Monday, the whole trial ends within that week. But now, the length has extended. And last year, it was beyond 10 days. In other words, it started on Monday, then it ends in the following day, the following week, toward the end of that weekdays. And also statistics shows that the number of people being acquitted rather than being convicted. And in the year 2009, since the act was implemented in May, the first trial took place in August, there were not many defendants being tried, 142, and every one of those being found guilty. So conviction rate was 100%. But if you go through from 2010 to 2018, and especially like 2017, the conviction rate fell below 98%. It may not seem kind of significant, but nonetheless, it's quite significant because under bench trial system, they almost always had well above 99% conviction rate. So at least there is a small reduction of the conviction rate when the lay participation system started, 2019. Now this is kind of a strange statistics because this is the number of sentences rendered by the quasi-jury and with a sentence beyond the recommended sentence by the prosecutors. And if you look at the 2010, 2011, 2012, and 2013, there are an increasing number of sentences which went beyond the recommended sentence suggested by the prosecution. And this gained a kind of very frenzied media attention. In other way of saying, all of a sudden, the the docile, very subservient Japanese jurors, right, now began to act on their own beyond the recommendation of the prosecutors. So when 19 cases with the sentences beyond the recommendation of prosecutors, the Japanese judicial body reacted and then began to began to provide reports. And even 2013, the 3 death sentences rendered by quasi-jury was reversed by the Tokyo High Court, and it was commuted to life sentence. And 2014, that's when the victim statement, that is the families of victims were allowed to make statements while the trial was going on. Okay? And then it began to collude the content of deliberations. Like the jurors began to talk about the sentences before they are deciding on whether we should convict the defendant. So the Supreme Court gave the directive. You have to have a bifurcated system. First, you have to concentrate on the conviction phase. Then, upon the conviction of the defendant, then you have to deliberate on the sentence. So that was the 2014. And afterwards, the number of sentences that went beyond the prosecutor's recommendation declined. So that was kind of interesting statistics. Okay, this is the jury candidates. We have long and very detailed statistics who become jurors. So I have a number of very interesting graphs. And some are in Japanese, but nonetheless, I converted it to English. So you should be able to understand, and it's in Spanish too. Now, for a 10-year period, the Japanese, 1 million people being identified as a potential jurors. And those are the people that the court sent the jury summons to appear at the courthouse. Not everybody of the 1 million people appeared at the courthouse. Only a little more than 300,000 appeared in the courthouse for the period of 10 years. That is 28% appearance rate. And it is kind of declining. And when the jury, the system in Japan started in 2009, you have 40% response rate. That is 2 out of 5 people received the request to appear at the courthouse, appeared, right? And for jury selection. But began to decline. 2013, it below 30%, and last year, it's near 22%. In other words, 1 out of 5 people who received the request to appear at the courthouse actually appeared. And this percentage is declining. That's something that the many people in the judiciary are concerned about. Also, deliberation had extended. In 2009, only 6 hours deliberation, right? Before they make a decision whether the person is guilty or not. Also, upon guilty, then decide on sentence. And so, if you started from 9 o'clock in the morning, the whole deliberation ended in a single day. But now, 2019, even this year, it extended 13 hours. So it's like at least like a 2-day deliberation. So you have to stay in the courthouse and you have to deliberate. It's more than almost twice as much than what you have. And also, this is the social composition, socio-economic composition of the jurors. And I dissected by the jury composition by the trial which lasted less than 3 years, and that's here, and less than 5 days, less than 10 days, and 11 days or more. And you have for employment people here. That's about half, I would say. And self-employed, and this is part-time employee. And together you have like a 70 to 75% of people who actually have jobs. At least they serve as employee in corporation or public sectors, right? Then you have, let's see, the homemakers. And there are many Japanese males who work as a home husband, homemakers. And they have less than 1% students. And the previous presenter talked about the renegade students. But you see a very small number of students actually serving in the jury. But you have unemployed people. those are pensioners who receive Social Security, and many of them. In Japan, still the austerity plan is being imposed, but still it has a decent Social Security system. And so many people with Social Security actually can survive. And you receive about close to $100 per day serving as a juror, so it's a really good income. So many pensioners actually actively participate. And so this is the Japanese census. This is the general populations. And people who are fully employed, well, only 40%. And self-employment is 7%, and part-timers are 14%. It's about a little over 60%. But if you look at the actual composition of people served, you have more representation. And also the people who are homemakers, right? You have almost, let's see, so 50%. But if you look at the people who are in the jury pool, they were less than 10%. So, students compose 2%. They were less than 1% in actual jury. And pensioners compose only 4%, but they constitute twice as many, like 7 to 8%. So in other words, the people who are young, like students, are excluded or self-exclude themselves, as well as the people who work domestically and as the homemaker, a wife and husband. They were excluded. So that's the composition of the Japanese jurors. This is the gender composition. Japan doesn't have the equal racial parity like you do in Argentina, which I think is a great system. I think Japanese should have the same kind of system. But nonetheless, if you look at the bottom, it will give you, excuse me, the, sorry about that. This is census, right? And you have more women in Japan, from even 20 to 40. You have more women than male. But if you look at the actual composition of jurors who serve on the jury, there are definitely more men than women. And even greater the length of the service that you have endured. The longer the jury trial, less women serve. And what's concerning is like a sexual assault cases, sex crimes. And women's representation is only 40%. 2 out of 5 people in those trials are women. And so that means women's voices are less likely to be heard and being expressed in deliberation. And that's why I think Argentinian system of racial parity is very significant. And I think Japan should model that. Now, court testimonials. Japan used to have the dossier trial. That is, everything was based upon the written documents. And I'm sure that the Argentinian system was based on dossier system too. Like investigators create a document, right? And the judges use those documents on the basis of the evidence that they deliberate and they make decisions. So because of this quasi-jury system, Japan was trying to move away from dossier, the document-oriented system, into more of a testimonial system. The witnesses testify in court. But in the beginning, 2009, the number of witnesses testified in court was 1.6. It's a little more than 1%. And so oftentimes in a trial, you see the prosecutors actually reading the investigative documents instead of summoning the witness to testify in court. And it was criticized very severely. So the number of people who testify in court increased. And 2013 increased to almost 3 people. And this year is well beyond 3 people being called in. They have to actually testify in front of the lay and the professional judges. But the number of people who testify depends on who requests those extra witnesses. The prosecutors are the main organ that increase the number of witnesses to testify. Defense attorneys usually request only 1 person from the beginning to now. And so, and also, those are the experiences of the actual jurors. And 63% of the jurors said they understood proceeding. And only 6% said difficult to understand what was going on. And deliberation experience, overwhelming majority of the jurors who served in the trial, like 73%, participated fully in the discussion with the fellow lay judges as well as the professional judges. And only 7% said not satisfactory. And overall satisfaction of the experience, majority of people said very positive and very good experience. And additional 40% said good experience. In other words, by putting those together, 96% of people who experienced the jury trial said experience was either extremely positive or very good and very positive. Now, this is the court instruction. The instruction by the prosecutors were good, easy to understand, or how about the judges? How about the defense attorneys? And you can see tremendous changes. Those are over the period of 2010, 11, 13, and 14. And if you look at the prosecutors, and when the trial started, more than 80% of the jurors said the instructions were easy to understand, right? And it began to decline, but still, the large majority of people understood the instructions given by the prosecutors. How about judges? Judges' instructions are good and easy to understand, as always. And because the prosecutors and the judges went through the mock trials even before the adoption of the system very intensely. Defense attorney is the areas that needs quite a bit of improvement. And the people who understood the defense attorney's explanation never reached majority. And when it was introduced, 2009, it was 49%, and ever since it declining. And the most important and concerning area is here. If you see, the percentage of instructions given by the defense attorneys had increased significantly. So that's the areas I think that the defense attorneys need to work, as well as prosecutors. Okay, this is the yeah, 2 minutes? 5 minutes? Okay. 10. Okay, I'm going to finish very fast. This is the grand jury system, and this is a system that doesn't exist anywhere because I looked around hard. And so this is called the Prosecution Review Commission. It's a grand jury, jurado grand, and it's called the PRC, Prosecution Review Commission. That's a citizen review of prosecutorial decision. It was adopted in 1948, and it was revised 2009, at the same time that the quasi-jury system was introduced. And there are many grassroots organizations that supported the creation of this system. And one most prominent person who directly contributed to the introduction of this grand jury system is by the name of Thomas Blakemore. He's quite unique. He's an American attorney. He was a graduate of the University of Oklahoma Law School. So he certified American lawyer. And he also had scholarship to study abroad at the University of Tokyo in 1930s, before the beginning of the Second World War. And he studied law, and he's one of the very few people who actually took Japanese bar exam. Passing rate is like 1 or 2%. And he took that in Japanese. He passed it. And then he returned to the United States. And then Japan attacked the Pearl Harbor. And they had Second World War. And Japan lost 1945. He came back to Japan as a member of legal team of the Allied forces that occupied Japan. And he knew about the tremendous overbearing power of prosecutor. Japanese prosecutor single-handedly indict people who spoke against the policy of Japanese imperial programs and detain them, prosecute them, interrogate them, torture them, oftentimes they kill them. So that's the power of the prosecutor. So he knew about it because he studied law. He studied Japanese legal system. So he tried to create a system to curtail this overbearing power of prosecutor and had suggested this system. And he found the abuse of prosecutorial power is not the power to indict people, but the power not to indict people, especially people who have political power, economic power, and in society. So as I said, prosecutors were reluctant to indict politicians, government bureaucrats, and economic elites. So when prosecutors refused the indictment, refused to issue the indictment, then that decision will be reviewed upon request by the citizen by this judicial panel composed solely of 11 Japanese citizens. No participation of the judge, no participation of defense attorneys, no participation of prosecutors. Those 11 people randomly selected from the community, they will make a decision whether decision by the prosecution not to indict those powerful power elites, economic and political sectors, was improper, and so indictment should have been issued. Okay? And it was non-binding. So most often, even though this citizen review panel decided that the prosecutor should have indicted the corrupt political officials, prosecutors often ignored, rarely acted upon recommendation, but it changed 2009 when the prosecutors decided not to issue the indictment, and this review panel decided twice that indictment should have been issued. Then that second indictment by the review committee will become mandatory. So there have been 9 cases since 2009. Oops, excuse me. The mandatory prosecution had been issued. Akashi, like the first one is Akashi pedestrian bridge case. The number of people being killed because of the failure of police officers to supervise the flow of the crowds. Many people being stampeded, and even baby being stamped to death. And the deputy police chief was indicted because the prosecutors refused to indict their own people. So, and the citizen review panel issued twice. This person needs to be indicted. But unfortunately, the statute of limitation had expired. So the indictment decision was dismissed. Second one was 150 people being killed because JR West was the second or third most powerful and prosperous Japanese corporation. And they put more emphasis on making profit rather than the safety of their passengers. And because of the failure to install safety features in the train wrecked and killed more than 150 people. And so 3 people, the CEOs, prosecutors refused to indict those people. But the civil panel twice decided those people need to be indicted and prosecuted. But the judge acquitted in the trial those 3 people. Rikuzenkai, the 4th case, Osawa Ishiro was the most powerful Japanese politician. He was the leader of the leading Japanese party called Democratic Party. And he was indicted of the campaign financing law. And he was indicted twice by the review panel, but he was acquitted by the professional judge. And so, and on and on. And right now, the Tokyo Electric Power Company, 3 CEOs, the explosion of nuclear power plant led to the forced relocation of millions of people, especially from prefecture of Fukushima, including my brother-in-law. And they filed a lawsuit, but none of those people actually won the case. But anyway, so 3 CEOs that the prosecutors refused to indict, they were being indicted forcefully by the review panel. And trial started 2 years ago, but the actual trial will start by the end of this month by the judge. But my prediction is judge will acquit those CEOs based on, because those trials are not being subjected to side-by-in or mixed jury trial, where you have the lay participants. Those are bench trials. Judges rarely, unlike like a lenient decision by the prosecutors, Japanese judge rarely convict how it is. But anyway, so this is the system, Japanese. And so the last, just give me 1 minute. And the introduction of the mixed tribunal was a result of the collaboration of many grassroots organizations, as well as Japanese Bar Association, as well as like look at here I skipped. Okay, you can see that as a result of those organizations, Japanese Federation of Bar Associations, those are basically Japanese bar, Japanese Federation of Housewives, and actually exists Japanese Federation of very powerful organization of housewives. I know the person who was the leader, and we worked together. And Association to Protect Crime Victims, Japan Trade Union Confederation, the most powerful unions, backed the introduction of lay participation system, as well as council to bring back jury trial, and many others. Those are the members of the one of the most powerful grassroots organizations called Research Group on Jury Trial. And you have 6 prominent members. 2 of them unfortunately being passed away, and I'm also the member of more than 2 decades. You can see a lot of the pictures, creating and giving lecture, and many others. And this is as Andres Hajif and his group had published many books, and Research Group on Jury Trial did exactly the same thing. And we published many books to try to talk about the importance of lay participation in Japan, in Japanese. And this is one of the most recent books. More than 30 people around the globe chipped in their ideas why lay participation is very important, especially in Japan. And our objective is to bring back the civil jury trial. Not only the criminal jury trial, but bring back the civil jury trial, which operated in Okinawa Prefecture from 1960s to 1972. And then as you see, among the 30 people, we have the prominent scholar from Argentina. Here, chapter 14 was written by Andres Hafuch. He contributed the article using the jury to spread democratic reform in Argentina and beyond, which I translated. And it should appear as one of the chapters in the book. And many people contributed from the United States, Europe, as well as Argentina and other places. Thank you.
Gracias, Hiroshi. Abrimos a preguntas. ¿Le alcanza alguien, por favor, un micrófono por allá?
Gracias, Hiroshi, por este panorama tan interesante de una experiencia en un país tan importante como Japón. Yo te quiero hacer 2 preguntas. La primera, ¿por qué considerás que siempre en Japón hubo un 99% de condena? ¿Cuál es la razón? Y si en algún punto las cortes japonesas son una visión extendida de lo que piensa la sociedad, por un lado. La otra, preguntarte si el jurado civil que vos estás pensando que exista en Japón para controlar a las corporaciones debería ser también como el Saiban Inseido, o tiene que ser un jurado del estilo americano, es decir, del estilo nuestro, de 12 jurados.
Excellent question. One of the reasons that, despite the fact that the lay participation did not significantly lower the conviction rate, is because the prosecutors, I mean, this being actually analyzed already, so I just give you, that's not my research, but it's been published. The Japanese prosecutors bring to the Japanese, the quasi-jury trial, only of cases they know they can assure the conviction. And so even some case before the 2009, and one of the research done by the American scholar said the number of indictment issued by Japanese prosecutors actually reduced. Not because there are less crimes. Of course, there was some gradual reduction of crimes being committed, but rather prosecutors before 2009, the Japanese judges are uncritical of evidence, including concocted and forced confession. Right? But the jurors will be critical of the confessions in which the defendants themselves actually refuted, right? They were actually under duress psychologically and physically. So they are forced to make a confession. It happened many times. And so that's one reason, another way of saying. So prosecutors reclassify the case in a way that they bring the case before the jury, only those they are sure that the conviction will be reached. And because, do you remember I said the Japanese prosecutors are very powerful before the end of the Second War, right? That's one of the reasons this Japanese, American legal, what's his name? Excuse me. Thomas Blakemore, excuse me. Was suggesting that you have to have some panel to curtail and try to check the power of basically abuse of prosecution. But even though there was a 99% conviction of the indicted cases, even before the end of the Second World War, there were 494 jury trials. If you look at it. Japan operated criminal American-style jury system with the 12 the citizens being randomly selected from the community. It's more of a symbolic because for a 15-year period, you only had 484 jury trials. That means the average of about 30 jury trials. That means you only have one or two, if not three, jury trials per month, right? And so even in those cases, prosecutors are sure that they will get the conviction. But 17% of those cases resulted in acquittal. That means 1 out of 6 cases brought by the ever-powerful prosecution still resulted in acquittal. They could only achieve 83% conviction rate. So that's the kind of power that people have to check the power of the prosecutors. Power of the government. So I would probably predict if we have the criminal jury system, because it's only being suspended, the law still exists. So if it's now being resurrected, and then I'm pretty certain the acquittal rate will rise, definitely. And the second one, civil jury, and if you look at, let's see, there were 4 civil jury trials in Okinawa from 1964 to 1972. So there are not many jury trials. So if you look at here, there are 11. The jury trials took place in prefecture of Okinawa, from 1960s to 1972. And 2 of those cases, criminal cases, defendants escaped the island right before the trial. So it failed to be commenced. So you only have a 5 criminal jury trial, and as well as 4 civil jury trial. But in the case of 4 civil jury trials, the plaintiffs were all women. And they were either widow, lost husband due to accident, and the widow sued the corporation, the U.S. multinational corporation operating in Okinawa. That's a construction company. And sued that. And she also sued the U.S. multinational insurance company that actually insured a vehicle that killed her husband. And she was actually Okinawan. She married the American service person. And she won both cases, along with 2 other American women sued U.S. multinational corporation as well as the most powerful local power company. So 4 civil cases, all plaintiffs, all women won cases against corporations, powerful corporations. It's 100% and winning ratio. And they won anywhere from $22,000 to $125,000. Remember, it's almost like 60 years ago. It's almost $125,000, like $1 million in today's the equivalent currency conversion. And the jury was truly international. Anybody who stayed on the island 3 months or more was eligible. So many Americans, including soldiers, their families. This was during the Vietnam War. So Okinawa was like an outpost of the U.S. military bases. 20% of Okinawa was occupied by U.S. military bases. And also Okinawans, also Filipinos, there are many Filipinos work in military bases. And I found there are many Arab merchants and business people operating. And if you look at actual names, there are the Arabic names there. And they're also traders. They work in a trade company. And they all served in the jury. And also, one of the criminal jury trials, it depends on the judges, how the judge actually act in the deliberation process. They guide and frame the discussion, the frame order of discussion. So they also allow the jurors to actually explore their independent ideas and based on free thinking, free will. So I think it depends on the kind of instructions and kind of parameters set by the judges. And but one of the penetrating critique of the influence of judges is that the judge actually make a determination on the law, the kinds of evidence to be introduced. And despite the fact that the jurors do not have any information on the evidence, but judges have. So they have kind of predisposed ideas, and based on the experience, they set the parameters within which the kinds of evidence need to be exposed to the jurors. So I think it's been mixed, but I would say it is inevitable. If you have professional judges in the deliberation with the lay judges, it is inevitable. You have an influence, either not in terms of the actual words, but the kind of atmosphere that the presence of professional judges create in deliberation room. Especially the deliberation is now beyond 13 hours, right? So you are actually in the same room. Instead of like 6 hours, you're done started from 9 o'clock and by 5 o'clock you're gone. But now it's over 2 days, if not 3 days. And ever presence, the presence of professional judges in the same room definitely influence psychologically the way the lay judges perceive the kinds of power structures that exist without speaking even word, I think. So I prefer the like Argentinian style, not Cordoba style of the system, but Argentinian style, all citizen jury system. I think that's the best word. And also using the gender parity, that's quite important. And also jurado indígena, right? The parity on the basis of indigeneity, because we have many indigenous people living in Argentina. And so their voices need to be also incorporated. And I have written a book called Affirmative Action in Jury Selection. And it's been sold quite well, because I used that in my class too. So it's sold close to 2,000 copies. So I talked about the use of quotas to increase the diversity in terms of gender, in terms of the race, ethnicity, and very important components, right? But unfortunately, and as Sherry said, there are too many baggages. The Constitution, I mean the Japanese, U.S. Supreme Court would not allow the use of quota to increase the diversity of the jury. But Argentina doesn't have that. So I think it's very quite unique. And I think that can be mirrored in jurisdictions like Japan. Right? There are more women in Japan, but if you look at the actual content of jury composition, there are more men. And longer the trials, more men actually being included in the trial. It's not fair. And I think Argentina has succeeded in establishing a very equitable system of lay participation. But one thing I want to say is, and this is based on my observations, it has been always a pushback. I know because we are one of the strong proponents to introduce the lay participation system in Japan, working with other grassroots organizations, progressive groups. But ever since 2009 happened, there have been a strong criticism by the scholars, by lawyers, by the media, and especially Prosecution Review Commission have been under attack by the politicians and the business people, and openly, because they have been actually targeted by the Prosecution Review Commission. So I like the word said by Amy Goodman. She's the host of Democracy Now! Maybe some of you may have actually seen. And she has written a number of books, and she said, democracy cannot rest, because always the people who try to eradicate the kind of democracy won through popular struggles, they are almost always under attack. So you cannot rest. You keep resisting and making sure you're fighting, not only to preserve, but even make a great improvement. So you cannot rest that way. And that's we know as a group of the research group in jury trial, because we have seen it. Even our own group began to turn, and they began to create a schism. And so once powerful, this grassroots organization had been split into two. We began to mend under the banner of pushing for the introduction of what we originally wanted, jury system, not the mixed tribunal system, especially extending not only criminal, but the civil domain. That's one of the reasons we have more than 30 people contributing their opinions of why lay participation is important. And thank you for your participation in contributing that article, and many others.